Professor Allan Rocha is a professor and researcher in civil law, copyrights, and intellectual property in Brazil. He teaches at several different universities, including in the graduate program on public policy strategies and development at the Federal University of Rio de Janeiro. And several of his students or former students are in the room today. And he's also researcher and vice coordinator of the National Institute of Technology and the Proprietas Network, and he's scientific director of the Brazilian Copyright Institute. Also relevant to our topics today, he's a copyright open access policy advisor at the Oswaldo Cruz Foundation, known as Fiocruz, which is a very important public research institute in Brazil. So Allan, over to you.
You do have the two texts that we were actually going to talk about a bit. So in one of them is like the part that I will talk about this, how the Superior Court of Justice actually applies fundamental rights to the copyright interpretation. But before that, I'm going to take up two subjects that Thomas brought up and Sean as well. One of them is considering the systems, the copyright system and the civil law systems. I actually think, and when I recovered like some of the studies on copyright, on comparative law, that's actually was the paradigm that carried comparative law up to the 80s. Up to 70s and 80s. After that, when it came to globalization and when it came to the real internationalization of law, which the effects were already being felt before, I think comparative law actually moved away from that to actually look up, and we see an ascendance of a focus on what are the particular and local cultural traditions that actually impact not only lawmaking, but the application of law or the practice that we want or desire to see happening. And I do think that change is not yet reflected when we talk about copyright, and it's not reflected when we talk about limitations for sure. And I think that is a paradigm change in copyright and comparative law perspective that we should sort of incorporate and look further into this. And we can see a few change that happened in the last 30 years that actually makes us move beyond that division. One of them, and I listed a few of them, is the real internationalization of law and what we call globalization, WTO, and TRIPS for IP specifically. Also, the European Union, as Thomas said, if I'm not mistaken, that's the judicial, the legal structure of the European Union moving ahead and getting implemented with directives of different sorts of type that will actually need to be implemented in the countries. I think the tentative harmonization, which at the very end seems harmonized, but at the same time it has a lot of variation within the structure under which they should be. And we see that variation within different European countries' copyright law in diverse aspects. And just one example that just came up to my mind, if we talk about the different levels of limitations and exceptions for education, or on the other hand, who is the author of a film? All the different categories are different within different European countries. Although they are harmonized by directive, they are harmonized also by the international instruments. So this is to say that there is a huge variation within its own systems. Like what New Zealand fair dealing is not exactly what the English fair dealing is, which certainly not like the American fair use, which from a different perspective, they seem very similar. And they are very similar to another feature that traditional civil law countries have. We do have general clauses, which are concepts that are necessarily undetermined by the legislator. They are open, they are semantically open. They can mean many things. And I'll give you an example that's within not only commercial law since the 19th century, actually, but also in civil law situations, which is good faith. Good faith is certainly not a self-explained concept, and it's not easily to apply. It does not have a predetermined meaning, but it has a very broad, open meaning. And that meaning is applied by courts. The meaning is defined by courts, and it's defined differently in different jurisdictions. Also, because of another fact that law is law making, law writing, and law application and practice are very deeply rooted in cultural, social structures and well-being. So once we have that in mind, I think we can push aside a lot of the preconceptions of the supposed difference between the systems. And we stop looking at systems as broad, and we start looking more locally at specific expressions of what would be a general principle that should be harmonized. And to a point it is harmonized, and to a point it's not harmonized. But that is a different question. Well, it's a background question that we will need to, I think we should face in order to get over this artificial categorizing distinction, because all categories are simply man created and we can overcome them. And once they don't explain anymore the world around us, they should come down and be substituted for new categories, which are much more nowadays fluid and open, and where the transitions and the frontiers are not so well established, a little more liquid concepts rather than very solid concepts, which are very much related to past century. But okay, that being said, one of the changes that came about and actually brought together a lot of different countries from different regions, and it seems to be a good guideline, and it seems to be the guideline that's actually applied across different systems and different national legal systems, is fundamental rights, the centrality of fundamental rights. I think the centrality of fundamental rights within legal systems has repositioned the role of courts, has repositioned the role of legislators, has repositioned the role of private acting. And that brings another point very attached to that. Once fundamental rights become really the center and the base, the ground rights, the ground rules from which the entire system is understood, interpreted, and applied, then we actually go to the point of having to balance different fundamental rights, which needs to be harmonized with copyright and everything else, for all different sorts of fundamental rights, be them individual fundamental rights or be them collective fundamental rights. Once you start reframing this entire system from those lens, and this has happened more intensely in Europe, maybe a little before, but more intensely, definitely all over the world in the last 2 or 3 decades, become even more present. By that, I mean like all different private relation issues have been reframed under those categories. And to give an example of different types of families, of what combination of people make a family. Traditionally, there were only like, it has to be a man and it had to be a woman and they had to be married and so on. That's what constituted a family. Obviously, the courts and later on the legislations, in many cases, in many situations, actually the courts set up the stage. They actually created the rule and changed that in all different places. And to give an example, more obvious example are the inclusion of same-sex marriage and civil unions all across the world in the places that happened. They usually came by courts. They did not come by legislation in the most part. And that's just one example. So just beyond, besides copyright law. So more recently, what I see is that copyright is also becoming reframed and looked at from a fundamental rights perspective, from the need to harmonize all different fundamental rights that apply and that actually have to live with copyright protection. And once you do that, you take a step outside the realm, that little space where copyright right holders and copyright, even academics and whatever, the copyright peoples are comfortable with. So you have to step out. Once you step out of copyright and you start seeing copyright not as an island, which is still seen by many practitioners, definitely lawmakers, definitely right holders, and even some academics. Once you put copyright within the system, you start looking at it very differently. You start seeing that the legislation itself needs to be a representation of that balance. And once you start seeing that, you start seeing that most of the legislation does not represent a very fine harmonization between different fundamental rights when applied to copyright. And it goes in all sense. You go in contractual protection, consider like if the highest point of copyright is actually protecting the author, where are all the contractual protections for actually protecting the author from being dependent on whoever? Okay. On the other hand, where is the balance? Where is the projection of other fundamental rights in dialogue of copyright in most copyright laws in terms of limitations or exceptions? And that is the exact point which the court case which I cited, which I'm basically citing that and working on that primarily because that's the paradigm case in Brazil. That was the first case within the new copyright law, within the new constitution, like framework, which is from 1988, which faced the question of how to interpret the limitations within the law. So we specifically faced those questions by framing the main issue as should that list that's contained in the copyright law, should that be interpreted exhaustively? It's only those cases, or those are just examples of the uses that can be done without authorization, without remuneration. The real discussion about it started like in the first decade of the century, academically and more in the public policy arena, that knows those interpretations are not enough, and because they are not enough, they need to be interpreted extensively. Although it's the first case that faced this law under this constitution directly, it's not the first case in the Supreme Court history, because in the 1980s, there was a Supreme Court case under the prior constitution saying exactly the same. And the case was citation was only from books to books, but there was a time of television and radio and so on and on and on. Would the television show be able to cite another television show or other material for a new program? And the Supreme Court decided that yes, it could, because the limitations were not contained in what was listed in the copyright law. We hadn't had one for the new law under the new constitution, which is very heavily fundamental rights based, which actually made a big turn on the interpretation and application of legislation in Brazil. In this case, it made the collective management facing the Catholic Church. And I think that's one of the reasons why he actually moved up to the highest court. It did not go to the Supreme Court. In Brazil, the Supreme Court only deals with direct constitutional issues, while there's another court called the Superior Court of Justice, which faces and deals with issues, which is the harmonization of the interpretation of infraconstitutional law. And when they do the interpretation of infraconstitutional law, they actually do use constitutional arguments as well. And that's a proof of how constitutional arguments have actually spread out within the system and are made to apply to every situation, including private law relations. Going back to the case. This case was about the opening of a school year in a religious school. And they played music in the opening ceremony. And the collective management organization went there to charge, fees for public music performance, because it's not into the law, that kind of situation. In theory, you could only use materials to illustrate classes in a very restrictive way, and there's no religious space for religious worship or religiously based arguments of the right to religion, right to worship arguments. That's not within the law at all. So the case moved up for the state appeal and then it went to the Superior Court, which harmonized the entire interpretation of federal legislation by applying fundamental rights and verifying if the situation itself, although not predicted by the legislator, was something that the Constitution allowed it for. And that was the key framing of the question. If that was the case, basically meant that the interpretation of the entire set of limitations must be seen as examples, as extensive interpretation. That's what he meant at the end, that there would be an implicit general clause of social function of property applied to copyright. And that's why the courts are allowed to actually interpret the cases in the face of what's set there, but not limited by what's set by the rules. And it goes further. It does say that the fundamental rights, they oblige not only the legislators to do this balance, but they oblige all powers, all public institutions to actually do that balance as they do their practice, including the judiciary. So the judiciary cannot omit from the responsibility of verifying if the legislator actually balanced it enough to have included or excluded certain acts. Because once a thing it did not balance enough the fundamental rights that need to be projected on the limitations and exceptions, therefore the judiciary not only can, but must act in response to apply the right balance of fundamental rights to copyright law, inclusive. And that is also a fact with other sort of legislations all over, different legislations. I'll share a little bit of the decision that's translated to English, but it needs a few corrections still. So the basically very short summary of the decision does tell us of the need of a systematic and theological interpretation of what's set into the law, because it needs to ensure in every application of the law, the protection of all different fundamental rights in collision with author rights. So there's a clear and explicit recognition that copyright does collide. It needs to be harmonized with different fundamental rights. Okay, and there's some examples here: privacy, intimacy, right to education, to culture, and religion. And it goes beyond. The effective scope of copyright protection arises only after you consider the limitations and exceptions. Considering the limitations and exceptions are an intrinsic part of the copyright law that must be interpreted and applied according to fundamental rights. The interpretation is not like, well, sure, now you can interpret anything. You can just add up whatever cases you want by interpretation. No, the interpretation would have a limit, and the limit would be the three-step test. And this is what it's being balanced. One rule on Article 68, which does, you need to pay for public music performance on any public performance in places of collective frequency, which would be a school, for example, would be set as such, a church would be set as such, as a place of collective frequency. And at this point, you remind us that fundamental rights and guarantees have direct and immediate applicability binding public authority as a whole. There is a duty to optimize and confer maximum possible effectiveness. And this is another thing. We must step out of the copyright structure to actually really rethink copyright, to actually really understand what the protection really means, what's the extension of that protection. And that's, again, they repeated here that these limitations ensured from the ponderation of such values in certain situations should not be understood as an exhaustive list of existing limitations. They are just examples, and that's what's basically set there. And then going back to TDM, values such as culture, science, intimacy, privacy, family, national development, freedom of the press, religion, worship must be considered when conforming right to copyright. And then, however, it cannot be arbitrary. And then it goes on and explain why that case is possible within the three-step test. And finally, their argument that copyright needs to be balanced with all different sorts of fundamental rights, including explicitly science, is what would give us an opportunity, in Brazil specifically, to move on and say that we could have data text mining limitation as of now, as it doesn't really conflict with the regular exploitation of the norm, and it is a means for science, knowledge, development, access to knowledge, and so on and on and on. So there is a case that can be legally made about that. However, we've taken a different strategy so far in Brazil in facing the TDM possibility of being a limitation. We reframed how we argue about the need for TDMs, exceptions and limitations on TDMs, by reframing it as an AI issue, not as a copyright issue. It's an AI issue that has a small impact on copyright. By doing so, they actually moved on the parliament in a reasonably fast way, much faster than it would any other limitation, as if it had been framed as a copyright limitation itself. It got approved by the House of Representatives, and it's now in the Senate. And in the Senate, they created a committee, and for which one of the researchers that we dialogue strongly with, which is Mariana Valente from Internet Lab, is part of the commission. And under that commission, there is one heading, which is database and TDMs. And there was a public consultation, which I made a presentation on that. And apparently that was very convincing. And what my conversation with the representatives, both in the Senate and in the House, is that basically everyone, the whole political spectrum agrees that needs to be one, and that it's key for innovation. So we reframed it not as much as a right to science. It's a key process to innovation. And if you want to create an innovative environment, that needs to be there. And that is highly important for science as well. And only secondarily it impacts copyright. So by reframing it as a governance issue, as a promotional issue for innovation, development, social development, science, and all of that, so we were able to actually move that on forward. Just to finalize, civil law systems are used to interpret and apply the law as the courts see it should be interpreted. That's how it actually has changed throughout the years. And following the same rhythm, ideally, we have a breakthrough in the decision making, and that breakthrough gets a positive reception, and that gets included into the legislation further. And that's not different than what happened with fair use in the US. That's the process that civil law legislation evolves as well, is by counting on the legal decisions to highlight certain aspects that were not specifically dealt with. And secondly, all civil law systems have that. They do apply analogy. And what's analogy? Then the possibility of extending one command that's made specifically for one situation to other situations. Going back to the basic and initial discussions, I think it's way time to overcome the argument about those distinctions, because they're much less so in the larger macro world than they are different within the micro world. So I think we should move on beyond that and see what harmonization is possible, considering the local necessities and also the local legal, cultural, and thinking, and the weight of the arguments. In some places, usually the economically more developed nations, I see the economic argument being very strong, having a very strong impact. On the other hand, I see in countries where that development is not so equally distributed. And just to give two examples, Brazil and South Africa, the need for social development, for a little bit more of a social equality, becomes highly important. And therefore, that's also considered by the courts. And it must be considered by the courts. And just really to finalize, from that decision, we've had like a lot of other decisions, considering the amount of copyright decisions that there are, and none of them contradicted this basic one. This basic one actually became the paradigm. And within these 10 years, we moved, especially education. Education was really strong. It was made huge gains by applying this extensive interpretation. Say, no, I can use any material for illustration to the extent that it's needed. Not only that, but I can perform music and theater and whatever within the school space, not for class itself, but as part of the work of the school of bringing the community together. Those limitations would apply for the online teaching as well. So we do have all these steps being taken by the courts, using analogy or using the idea that we need to balance copyright at every situation. So at the end, in order to expand all the possibilities for a better balance, we need to look outside of copyright. Just within copyright framework, it's not going to work, because the copyright framework and the debate within copyright, it's all very dominated by the right holders, organizations, and so on and on and on. So it's by stepping beyond, we can actually bring fresh air into copyright system and actually refresh it. And that's what it really needs before it dies, before it becomes absolutely irrelevant. And that direction is where it seemed to be going towards. And now with the new, and then that's a new subject, with the new, let's say, platform world and vigilance and digital vigilance and control and so on. Now we're back a few steps on that sense. The final words is that, yes, there are really not many difference between two big systems, but many more difference within the systems. And all those systems face the same issues, but just face it differently, but to get to the same results. So courts have always had some role, and they have had an increased role in civil law systems since fundamental rights became the new framework of the systems. That's it. Thank you.